Welcome, and thank you so much for joining us today. Today we are sharing with you HR 101 Essentials for Managing Your Workforce, and we are excited to talk to you about all the great things that are basics that your companies need to know. I'm Brittany Pierce, chair of our Ryan Swanson's Employment Rights and Benefits and Labor Group. And today I'm excited to be joined by my colleagues, Kristin Nealey Meier, Hannah Kern, and Madison Burke. For those of you who aren't already familiar with our firm, Ryan Swanson is a full-service 40-attorney law firm based right here in the Northwest. Each one of us here today are members of the firm's employment group, and we have a bigger group as well. We work with businesses and owners and HR professionals regularly at all levels to help them implement practical, creative solutions to protect their businesses from potential threats that can disrupt their workforce or business operations. Presentation slides are posted on our website as well, so please feel free to go to ryanswansonlaw.com/events to download them.
As Brittany said, I'm going to be talking about leave laws and some laws that may not technically be leave laws, but certainly impact how you analyze your employee's request for leave or the necessity of an employee taking leave. So again, as everybody else has done, I'm going to provide you an overview. This is not every piece of information that you need to look at when you are determining what leave laws apply to the individual situation of the employee. But hopefully this will give you enough of a framework to be able to issue spot and figure out where to look for further information. So it's important to recognize, as everyone else has identified already, that there are federal laws and state laws which apply here. And as is the case in almost every employment law, you must use the one that is most generous to employees. And there are, almost all leave laws have both federal and state law. And so you'll have to figure out which one to apply in any given situation. It's also important to understand whether all of these laws that may apply to the situation your employee is in will run concurrently, which means you can use these two different types of leave at the same time, or whether they will run consecutively, which means one law applies for a certain amount of time, and then the other one kicks in. Most often, these leave laws run concurrently. So you won't have to, for example, apply the federal law for 12 weeks and then the state law for 12 weeks. But there are certain circumstances where the leave laws will be consecutive, and it'll be helpful to know that. So leave laws are alphabet soup, like a lot of other things in employment law. And these are just a handful of the acronyms I'm going to use today. So you can refer back to this if you need to. The Americans with Disabilities Act, the ADA, and FMLA, which is the Family and Medical Leave Act, those are federal laws. And then the remaining three are state laws. The ADA is not technically a leave law, but it does impact whether or not your employee may need to take leave, and certainly impacts leave laws. So we're going to talk about that as well today in the presentation. When you signed up, you should have received an email this morning that contains some information, which includes this handout, which I think is really handy. So if you, for some reason, did not receive this or would like a separate copy, please let us know. This lays out for each one of the laws that I'm going to talk about today when they apply. And again, this is really a cheat sheet to get you started. This is not a comprehensive analysis of whether any particular law applies to your employee's situation, but can at least help you get started. So you will see the columns that identify each of the laws. And then underneath that, you will see how many employees the employer must have in order for that law to apply. For example, the first column is the Americans with Disabilities Act, which is the ADA. That only applies if you have 15 or more employees. So if you have 10 employees, that law does not apply to you. However, the Washington Law Against Discrimination, which contains a disability law similar to the ADA, that applies only to 8 or more employees. So if you do have 10 employees, then the Washington law against discrimination does apply. So underneath the category of how many employees your company would need to have in order for it to apply, it's sort of a bullet point of kind of the most important points to look at when you're looking at these laws and whether they apply to either your company or the employee, whether that employee is eligible to receive that type of leave. So again, this is a starting point for you to understand kind of what may apply in any given situation. And we'll go over these in a little bit more detail, but I have been practicing for almost 2 decades, and I still have to refer to things like this chart and resources on different websites that I'll let you know about at the end, because there's little issues that come up that you need to go back and refer to and double check, like Brittany was talking about with the payroll deductions, to make sure that you're doing this correctly. So we're going to start with the ADA and the Washington law against discrimination. And both of these essentially say you cannot discriminate based on a disability. And I'll talk a little bit more in a moment about how this affects leave, but it's important to understand that Washington's law defines a disability much more expansively than the federal law does. And so it's most likely that you will need to apply, at least in terms of defining the disability, the Washington law. So the framework of both of these laws is that if an employee has a disability, then the employer must provide an accommodation if that is going to help the employee perform the essential functions of his or her job, but it doesn't cause an undue hardship or a threat to safety. Now, the guidance that has come down from the EEOC and the CDC has deemed the pandemic could be a threat to safety. And so a lot of what I'm talking about may or may not apply to a COVID situation. That is a whole different seminar and a whole different set of questions that we would be happy to answer. This is kind of more of a general framework. But when you're talking about an employee who may have a disability and needs some help in figuring out the best way to be able to work, you're really going to have to walk through what's called the interactive process. That's the last bullet point here. This whole issue regarding the disability requires communication with your employee. And this is where it kind of tags onto leave. Leave may be a accommodation under the ADA, not leave forever. There has been no court that has said unlimited leave for the remainder of time is a reasonable accommodation. But the Ninth Circuit, which oversees our law here, has a little bit different idea of how long of leave might be necessary. So again, the ADA is much more complicated than we can spend a few minutes on, but it's important to understand that if you learn, and this can be because the employee told you, or because you have noticed that the employee has not been able to perform the essential functions of the job, you're talking to them about why that is, what can we do to help you perform better, and they pop up that they're depressed, right? That triggers this process of trying to figure out how to help this employee, and may then lead to the need for the employee to take leave. And that sort of dovetails into the rest of the conversation that we're going to have today. Probably the most common type of leave that you may have heard about is, especially if you're an employee with 50 employees or more, is FMLA, and that's the Family Medical Leave Act. This is a federal law that allows an employee to take up to 12 weeks of leave, and it's unpaid if they have medical, the employee has a medical reason, or a member of their family that's defined in the law needs the employee to take care of them. And there's some qualification floors here. The employee has to have worked 1,250 hours in the prior 12 months. And the real key to FMLA leave is that the employee's job has to be available when they return. So it is a job protection law that you don't have to pay the employee, but you do have to keep the job open for that employee when they return from leave. There's a lot of questions about what that looks like. If you have a specific question, please feel free to put that in the Q&A box and we'll try to follow up on that. Another real key piece of information is once you learn from the employee that they need to take leave and it is an FMLA eligible reason, they need to take that within 5 days. So you can't say, okay, well, we'll start the clock in 3 weeks because you have enough vacation and sick time accrued. You have to start it upon learning. And so they can still use that sick leave and paid time off, but it will be within the 12 weeks instead of adding to the 12 weeks. Now, the state Washington law here is kind of expands the definition of paid time off so that even if they're using sick leave or vacation leave, if you provide one of your employees paid time off in whatever form, that employee is entitled to use that to care for their family member. So they say, oh my gosh, my kid's sick, I need to stay home, and they use a vacation day. You can't say, well, that's only for you to take vacation, and I only want you to take vacation, because that's what it's used for. I'm hopeful that you aren't quite that specific with your paid time off, but that's what the WFCA provides for you. A newer law in Washington is paid family medical leave. And this really is not a leave law as much as it's a paid law. So this does not provide job protection like FMLA. It's a program that the state administers that provides pay to eligible employees during their time off. So if you are administering an FMLA program at your company, then they can get this job protected leave, plus they can potentially get pay from the state program through PFML. So employers are not required, if it's under certain circumstances, most smaller employees, they do have to collect premiums from a paycheck, like the other withholdings that you're already taking out, and then you have to remit those to the state. Now, employers can pay those premiums if they choose, but in most circumstances do not have to. They can just be taken out of the check. And then if the employee qualifies by a certain amount of hours that they've worked, then they qualify, then they can receive payment from the state program. It got off to a little bit of a rocky start, but I think that the processing that they have gone through has gotten a lot more streamlined recently. So pregnancy disability can be really tricky. In Washington, your job protection is for the length of disability due to pregnancy, not just your quote unquote maternity leave. So if there's complications during the pregnancy and you're exceeding the other leave that employee is qualified for, you need to really be careful. And that's kind of mostly what I'm going to say. I'm not going to go into details about every situation because it can really get complicated. But just know that if you have an employee who's having pregnancy-related disability prior to birth or has complications a few months after birth, then this is leave that you're going to have to really research and figure out what will apply to that particular employee. So there's some other leave that can apply in certain situations. Military leave, which provides job protection. Our state law provides some unpaid leave for if a spouse of an employee is being deployed. Domestic violence leave is available. It's also unpaid leave, but if an employee has to deal with a domestic violence issue, this provides that leave and requires you to provide leave, and in some cases, accommodation for employee safety, maybe not having that employee sit at reception, or in an open space if there's an issue and they're fearful for safety. There's a couple of different things unfortunately this is happening with the employee and requires the employer to take certain steps. And even though this isn't really leave, I wanted to include short-term disability because sometimes people forget about short-term disability. If you offer a short-term disability program for your employees, and those employees, if they are able to opt into that, then that can sometimes be a good avenue for that employee to go get the help they need, the medical care that they need, and potentially be able to come back and provide the services that you need them to provide. Sick leave, similar to minimum wage, is somewhat dependent on jurisdiction. So Washington State requires that an employee accrue 1 hour of sick leave for every 40 hours worked, which will kick in, and they can use that starting 90 days after employment. In Seattle, for safe and sick leave, and the safe leave portion of that is similar to the domestic violence law that is statewide. Depending on the size of the employer, the employee will accrue 1 hour for every either 40 or 30 hours worked. The bigger the employee, the sooner they accrue that 1 hour. So it's important for you to double check as you are working through your accruals and calculating how much time off an employee gets, that you check your jurisdiction. So as Brittany mentioned, there's some really good resources out there for all of these issues, including leave, and I've listed them here. The L&I website's laid out pretty well for employers for whatever the issue is, to really give you the framework for the questions that you need to ask. If you're in the city of Seattle, the Office of Labor Standards has some similar information specifically related to labor laws in Seattle. And then the Equal Employment Opportunity Commission, which is the agency that enforces federal labor laws, also has some pretty good information on their website. For example, the guidance that they have issued because of the pandemic has been pretty good and pretty comprehensive in terms of the federal law. And then of course, you'll need to check each of the jurisdictions in Washington State. And then if you're in Seattle also, but these are good places just to double check. Even if you think you know what the laws are because you've applied them a few times before, it never hurts to double check. We all do that here, even though we collectively have practiced for a really long time. You got to look it up, and we really encourage you to do that. And these are great resources to be able to do that.